I'm Bill O'Brien of the intellectual property, technology, and media law firm 1LLP. I've been practicing patent litigation, including litigating over patents, for about 25 years. I'd like to talk about what I think is one of the most interesting issues in the field of intellectual property law, which is the non-obviousness requirement for patentability. The views I'm going to express today are my own personal views and not those of my firm or of any of our clients. Patentability requires a number of features, but obviousness to me is the most distinct to patent law and one of the most interesting. There's really no comparable requirement in any other field of intellectual property. For example, for trademarks, there's a requirement of distinctiveness, but that's just so that the trademark can serve its purpose of distinguishing one source of goods or services from another. There's no requirement that the trademark be creative or advance a field of endeavor. It could be as mundane and obvious as you like. Copyright has an originality requirement, but as applied by the courts, that's very minimal. If I were to whip out my iPhone and snap a picture of this wall right now, that would almost certainly be protected as an original work of authorship under copyright law. In fact, there's recently been litigation over the copyrightability of a photo literally taken by a monkey. There's no requirement for copyright protection that in taking my photo, I exceed or even equal the skill or creativity of an ordinary photographer. That is very unlike patent law. Patent law imposes a number of requirements to receive a patent and have it upheld as valid. But to me, the most distinctive and perhaps the most interesting is the obviousness requirement. In terms of other requirements for patentability, there's a utility requirement, which just means that the invention has to be useful. Pretty much anything will do above and beyond merely saying, well, I can put it on my desk and use it as a paperweight. There's a requirement of enablement, which means that the patent application and patent must disclose enough information that a person of ordinary skill in the art can practice the invention without undue experimentation. That's simply an attempt to create a trade-off whereby part of the deal in which you get a patent is teaching your invention to the public. There's also a written description requirement that the patent application show that the inventor was in possession of the patented subject matter. That's basically to prevent retroactively patenting more than you really invented. And there's a judicially created prohibition on patenting certain subject matter, such as abstract ideas and laws of nature. That rule is creating a lot of uncertainty and problems in particular fields, such as patenting of business methods and many internet patents. But the requirements of non-obviousness apply to patents in all fields. The related requirement of novelty, like obviousness, is based on a concept that lawyers call prior art. And that is really just what was already available prior to the invention. The prior art is, for example, anything that had been patented, anything that was described in a printed publication, which could be, for example, a book, a journal article, an internet posting, even user instructions if they're distributed sufficiently, or something that's in public use, something that's on sale, or even just offered to sale, or otherwise available to the public. So patent law imposes requirements on how an invention to be patentable has to compare to the prior art. And the first requirement in Section 102 of Title 35 of the U.S. Code is novelty. It has to be new. That's not a very demanding standard. If you compare everything in a patent claim to the available prior art, is there an item of prior art that disclosed every single thing in the claim configured as recited in the claim? And some patents fall afoul of that requirement, but it's not really a terribly demanding standard. The standard of obviousness goes beyond that. It requires not only that you be patenting something that's different from what had been done or had been known before, but that it be sufficiently different, that it reflect a sufficient contribution to the field that it deserves a patent. And again, there's no analogous determination in any other field of intellectual property. So what marks out a new contribution that's sufficient to be patentable? Well, early cases spoke of things like a flash of genius. One judge long ago said, perhaps jocularly, that his rule of thumb was that if he could understand the invention, then it wasn't patentable. But over time, there was a consensus that developed that we needed a clearer standard and probably the one that was a little less demanding than the genius standard as interpreted at least by some people in some courts. In 1952, when there was a massive codification of the patent law, the standard that it was adopted was the obviousness standard in much the same form that we have today, and it's set forth in Section 103 of Title 35. And it says that one is not entitled to a patent if the differences between the claimed invention and the prior art are such that the claimed invention as a whole would have been obvious before the effective filing date of the claimed invention to a person having ordinary skill in the art to which the claimed invention pertains. So this is a hypothetical standard, which is a type of endeavor that the law sometimes gets attracted to. You could compare it to what Einstein would have called a thought experiment, in which the patentability of a particular invention is determined by asking a hypothetical question. And the hypothesis, first of all, involves a person of ordinary skill in the art, not a particular specific person, but a hypothetical person. You could loosely compare this exercise to the reasonable person standard in negligence law, where a jury would be instructed, well, if you want to determine whether the driver in his actions that led to an accident was negligent, ask yourself, well, would a reasonable person have acted that way? And if not, then that was negligent conduct. Well, an important difference with obviousness is that we're not talking about an average person walking down the street as being our hypothetical actor. Instead, it's a person of ordinary skill in the field to which the invention pertains at the time of the invention. A second way in which this is a hypothetical standard is that the statute specifies that the issue is the differences between the prior art and the claimed invention. And the courts have interpreted that as meaning that the hypothetical person of ordinary skill in the art is also hypothetically assumed to be aware of all of the relevant prior art. In one case, there was an analogy to this person of ordinary skill having put all the relevant art up on the wall around him or her. And this is obviously not a realistic hypothetical, in that generally the real people in the world of ordinary skill in the art turn out not to have been aware of much or all of what turns out to be the relevant prior art in a particular case, but it's assumed to fit the statutory standard. So what are the bases on which you decide whether a particular invention was obvious, and who makes that decision? Well, in 1966, the Supreme Court decided a case involving tractors, Graham versus John Deere Company, and said that obviousness is ultimately a question of law, a type of question that's normally determined by judges, but that obviousness is informed by underlying factual determinations. And the court in Graham listed 4, which are not necessarily exclusive. They're the scope and content of the prior art, any differences between the claimed subject matter and the prior art, the level of skill in the art, and what the court in Graham called secondary considerations. Let me briefly go through what those 4 underlying factual determinations are. So first, the scope and content of the prior art. There can be factual questions about what is prior art. For example, a defendant accused of infringement comes into court with a book. Well, when was that book published? Was it published early enough to be prior art, or was it potentially published after the effective date of the patent application? There's also a requirement that the prior art to be considered for obviousness has to be analogous art. So that means it has to be from the same field of endeavor as the invention, or it has to be something that a person of ordinary skill in the art would have considered reasonably pertinent to the problem faced by the inventor. So if you have something a feature that was disclosed in some kind of unrelated document relating to what somebody working in this field would have regarded as unrelated, they would not be assumed to have been familiar with that. There's another set of factual questions about the scope and content of the prior art, which is, what does that prior art teach? What would one of ordinary skill in the art, once they're assumed to have been familiar with it, what would they have understood it to be telling them? And that, of course, can be a highly disputed issue. The second Graham factor is any differences between the claimed subject matter and the prior art. So that's a comparison of the claims on a claim-by-claim basis to the prior art. We've just talked about the issues about the prior art. In practice, the scope of the claimed subject matter isn't really a factual determination. This had not been clearly established as of the Graham case, but in the 90s, the Markman decision of the Supreme Court determined that the interpretation of the patent claims is a question of law for the court. So basically, you're taking the claim as construed by the court and comparing it to the prior art after the various factual determinations are made about what is prior art, what is analogous prior art, and what that art teaches. The court should instruct the jury if there are any issues about the scope of the claims that is relevant to obviousness. The court should instruct the jury on how to interpret the claims in those regards. So then the third Graham factor is the level of skill in the art. And first off, there's a question potentially, well, what is the art? What is the relevant technical field? How broadly or narrowly should it be interpreted? Then there are issues, well, what is the ordinary level, or more precisely, at the time of the invention, what was the ordinary level of skill in that field? And typically, an attempt is made to pin that down with some objective factors, like a typical person working in that field would have had a certain type of degree, a bachelor in science of electrical engineering, for example, or higher degree, would have had a certain number of years of experience in the field. Sometimes there can be other aspects of the level of ordinary skill that are in dispute and that are material to the obviousness decision. And then the fourth Graham factor was what the Supreme Court in Graham called secondary considerations. They're also sometimes called objective indicia of non-obviousness. And in fact, one panel of the Federal Circuit Court of Appeals upheld that terminology and criticized the term secondary considerations, even though their higher court had used that term. And it's true that these so-called secondary considerations do need to be considered wherever they're raised and are relevant. And the Federal Circuit has even said that the objective indicia evidence can even be the most probative and cogent evidence in the record. I think of the objective indicia as a reality check. If this is really so obvious, then what would we expect to have happened in the real world, and contrast that with what actually did happen. In the words of one Federal Circuit panel, it helps turn back the clock and place the claims in the context that led to their invention. So what are some objective indicia or secondary considerations? Well, one is a long felt but unresolved need. So if a patent owner who is trying to uphold the validity, including the non-obviousness of his or her patent, can show, well, there was a problem in this field for a long time. It was recognized, but nobody solved it. And then I did with my invention that I patented. Well, it raises a pretty pertinent question. If the solution was obvious, why didn't somebody solve the problem and fulfill the long felt need earlier? Another is failure of others. So other people tried and failed to solve the problem. Again, if the solution was obvious, why didn't they succeed? Skepticism, where people who are of skill in the field don't believe at first that the solution is possible or even that it's been achieved. I had a case, for example, where we called a witness who had seen an early demonstration of the invention, and he said, I was convinced I was about to waste an hour of my time. He didn't think it would work, but it did. The surprising results, again, people who are of skill in the field find it surprising that the invention worked. Commercial success can be an important objective indicia of non-obviousness, the theory being that if there was money to be made doing this thing that is patented, then and doing that thing was obvious, why didn't somebody do the thing and make the money earlier? The courts, however, are increasingly strict in requiring a nexus between the commercial success or the other objective indicia and the claimed invention. So there needs to be a showing, well, the reason for the success was the invention as opposed to any number of other factors, including that the company that had the success was a leader in the industry, they invested a lot of money to make the product successful, there was a change in fashions or in commercial circumstances, or whatever it might be. Copying can itself be regarded as an objective indicia of non-obviousness, and that can get into fights about, well, did the defendant copy the plaintiff or have others copied the plaintiff, and industry acclaim, like receiving awards or being praised in industry publications. That can also be an objective indication of non-obviousness. Now, there can also be objective indicia of obviousness, cutting the other way. For example, if you have independent development of the invention at about the same time by one or more others, that could tend to indicate, well, maybe it really was obvious. Maybe there was some reason for coming up with this type of product or method at this particular time, and multiple people did it independently. Now you can carry that too far. Descartes and Leibniz both came up with calculus at about the same time and did so independently, but it doesn't exactly mean that was an obvious development in the field of mathematics. Now, when you do your obviousness analysis, I mentioned before, but it needs to be emphasized that it's done on a claim-by-claim basis. And the claims, of course, are the numbered statements at the end of the patent that define what is patented, what is covered by the patent. And any product or method that fulfills all of the elements of any of the numbered claims infringes that claim. And obviousness of a claim is determined based on looking at each claim separately. And that means that there is a bit of a moving target in terms of the combination of features that needs to be proven to be obvious. So you can typically, for example, you'll have an independent claim, and then you'll have some dependent claims that incorporate the independent claim by reference and then add additional features. For those dependent claims to be invalidated for obviousness, you need to show that not only the elements in combination of the independent claim are obvious, but also the added elements. And how does one do this? Well, typically, the way that somebody challenging a patent claim for obviousness approaches it is they pick an item of prior art that has most of the claimed features or elements in it, and then they seek to combine that with one or more other items of prior art that supply the remaining elements, either as additional items or as a substitution for something that was in the first item of prior art. In addition to objective indicia of non-obviousness, there can also be objective indicia of obviousness. For example, independent development of the same thing by multiple people at about the same time, it can help to confirm that something really was obvious, that maybe there was some driving factor why a number of people needed this type of feature at this time, and they all, once they needed it, were readily able to come up with it, for example. But you can take that too far. For example, Newton and Leibniz independently invented calculus at about the same time, but that hardly means that was an obvious advancement in the field of mathematics. Now, as I said, and it bears emphasis, obviousness or non-obviousness is determined on a claim-by-claim basis. Of course, each patent ends with a series of numbered claims that define the metes and bounds of the patented invention. Each claim has a recitation of a number of features or elements, and if a product or method includes all of the elements of a particular claim, then it infringes that claim. If a item of prior art has all of those elements, it anticipates that claim, meaning that it's invalid for lack of novelty. And For obviousness, the claim is invalidated by showing that that total combination of features as recited in a particular claim would have been obvious to the hypothetical person of ordinary skill in the art who was hypothetically aware of all of the analogous prior art. So the way one usually tries to construct an obviousness case is starting off with an item of prior art that has most of the features of a particular claim, and then adding one or more other items of prior art that supply the remaining features, either as additions to the first reference, first prior art reference, or as substitution for some of those features. A given claim often has a recitation of items that many of which are in the prior art, with only one or a few aspects that are an advancement on what was already in existence. For example, I could have a claim for a laptop computer that includes a hinged cover that has a monitor in it, and a base that includes a keyboard and a processor and a battery. Then if I were claiming an invention, I might recite those things and then add to the claim a photoelectric panel that generates electricity used to charge the battery. So in attacking the obviousness of a claim like that, one might recite a conventional laptop that has all the features except for the photoelectric panel, and then a solar calculator or some other product that does have a photoelectric panel, or a standalone photoelectric panel that could be attached to somebody's house, for example, and hypothesize that it would have been obvious to just attach this to a computer. The obviousness of the invention, however, must not be determined in hindsight. So it's not that you take a claim and then use that as a checklist to go find things in the prior art. I mean, that's what in fact often happens when someone gets sued for patent infringement and puts together an obviousness defense, but that is not the hypothetical standard at all. The cases heavily emphasize that non-obvious and patentable inventions are very likely to look obvious in hindsight, and that must be guarded against. And the courts have, over the years, taken a number of steps to try to do that, and there's recently been some pullback on that. But the Federal Circuit, which is the main court hearing appeals of patent cases, usually the only court unless the Supreme Court grants certiorari to review a Federal Circuit decision, it imposed the standard known as the teaching, suggestion, or motivation standard, which was basically saying that if you want to argue that a combination or a modification of prior art is obvious, you need to show in the art a teaching, suggestion, or motivation to make that change or to make that combination. And as a practical matter, it was often pretty hard to find something express that said, well, the solar panels could be used with laptop computers, for example. The Supreme Court in 2007 pulled back on that quite a bit in a case called KSR versus Teleflex, involving automobile pedals, where the Supreme Court said, well, looking at teaching suggestions and motivations to combine known elements can provide helpful insight, but you can't require that as a rigid requirement for any finding of obviousness. Instead, common sense can provide the link, according to the Supreme Court. And the Supreme Court specified if you have a combination of familiar elements where they're being combined according to known methods, and they're yielding predictable results, that's likely to be obvious. So if you have, if you have a given feature performing a certain known function in a predictable way in one context, and you want to bring that into a different context where it's predictably going to perform the same function, that's probably going to be obvious. And the KSR test has greatly increased the amount of litigation over obviousness and the number of cases in which patent claims are being found to be invalid for obviousness. I'd like to walk quickly through various steps of litigation culminating in trial with regard to obviousness. And the first step is the pleading stage, where the party asserting obviousness needs to set forth a pleading making that assertion. Often it's an affirmative defense in a answer to an infringement complaint. It could also be asserted as a counterclaim to the infringement complaint, where you're asserting a counterclaim for a declaration of obviousness and invalidity. Sometimes if the accused infringer gets into court before the patent owner, they could file a declaratory judgment claim asking that the patent be determined to be invalid for obviousness. A set of issues that hasn't been fully worked through has been triggered by the decisions of the U.S. Supreme Court in Bell Atlantic versus Twomley and Ashcroft versus Iqbal, where the court significantly raised the standard for pleadings, saying that pleadings have to contain sufficient facts such that the claim that is being asserted is plausible on its face. That is not being consistently applied yet in the field of obviousness, especially with regard to affirmative defenses, where circuits and district courts are currently split as to whether the Iqbal-Twombly standard applies to affirmative defenses. So some courts are allowing a defendant as an affirmative defense in a patent infringement case to simply say the patent's invalid and then cite every patentability provision of the Patent Act, and others are requiring that the basis, such as obviousness, be specified. There may be requirements that specific prior art be specified. Conceivably, you can end up having to even chart some of the prior art against some of the claims, showing plausibly that the art did render the claims obvious. The main thing currently is to just try to know the pleading standards of the particular court that you're in. Another stage of litigation commonly now is the contention stage, where many courts have adopted local patent rules that require exchanges of contentions fairly early in a case, and some judges who are not in those districts have adopted those rules, using them as a model for their particular case schedules. So, for example, in the Northern District of California, where many patent cases are heard, there's a rule that the plaintiff has to serve infringement contentions, and then 45 days after that, the defendant has to serve invalidity contentions, setting forth the prior art that they're asserting, setting forth the bases for asserting invalidity, such as obviousness, and if they're asserting obviousness over a combination, identifying those combinations and charting where the various features of the claims are in the asserted prior art. In the discovery process, meaning interrogatories, document requests, depositions, and sometimes requests for admissions, there's an opportunity to build an obviousness case, even though the heart of it is likely to be the actual prior art and facts about that prior art. Both sides can use discovery to strengthen their case, and as well as to find out what to expect at trial. For example, a defendant asserting obviousness can go after admissions from the patent owner and its witnesses that there was a relevant design need or market pressure, which under KSR could help render the invention obvious. Another helpful point is if there are only a finite number of solutions and to an identified problem, and that they were predictable in how they functioned. Admissions like that can really be quite important in building an obviousness case under the KSR doctrine. On the other hand, a plaintiff can seek evidence, for example, that people were surprised by the results. They were skeptical, that the defendant copied the plaintiff's work, and that, as I mentioned, can be an objective indication of non-obviousness right there. Sometimes it could be uncomfortable for the accused infringers to be asked, well, why didn't they do this before if it was so obvious, if in fact they did it in response to the patent owner making the invention known. Patent cases typically have a claim construction process in which the parties identify disputes that they have about what particular claim terms and phrases mean, and the trial judge resolves those issues. The claim construction process gets a little counterintuitive when we get into obviousness, because typically the parties are focused on infringement, and with the patent owner trying to construe his claims broadly to cover as much as possible, and the accused infringer trying to go narrow on the hope that their product or method might escape falling within the scope of the claims. With obviousness, it's the opposite. The accused infringer asserting obviousness wants to make the claims as broad as possible, to pick up as much prior art as possible, and the patent owner would like to narrow things in a way that would avoid prior art if possible. So it makes sense for both sides to have a good handle on the obviousness case early on, so that they can inform their claim construction positions. Often there's a particular limitation that doesn't really affect the infringement case. It's clearly present in the accused device, but it could be construed narrowly in a way that would avoid a particular item of prior art. And if so, it's important to know that and try to get a construction that will take advantage of that. The KSR case has resulted in greatly increased importance of summary judgment to obviousness cases. There's a subjective aspect to obviousness, such that even though it's theoretically a question of law, the courts had, in many cases, been fairly routinely denying summary judgment of obviousness. The court in KSR has encouraged courts to resolve obviousness issues by summary judgment where possible, and if there aren't material factual disputes, there's an increased trend for the trial judge to take the issue away from the jury and make the call. And The most interesting forum for litigating obviousness, pretty obviously, is the trial. Trials are the most fun and complex aspect of a litigator's work anyway. I think that trying issues of obviousness is particularly fascinating because it is such a complex yet hard to pin down type of issue, being tried to a group of average citizens who typically have no background at all in the relevant technology, and yet have to make a judgment about whether a particular improvement in that technology is sufficient to deserve patent protection. And it's pretty interesting to think about that process and about how, as an advocate, to influence that process. To me, a trial is like a play in which two competing playwrights try to put on different stories at the same time. One playwright is telling a story that leads to the conclusion that the plaintiff deserves to win, and the other that the defendant deserves to win. Well, who's going to win? The one whose story is the most clear, compelling, and plausible to the jury. And what makes for a persuasive story? It's the same in court case as in any other context. Developed characters, understood motivations, a context for understanding what's happening on the stage. It's important as a storyteller not just to tell what happened, but try to explain why it happened. Trials, I've been in several trials that were 2 to even 3 months long, and the days of long trials in patent cases have really come to an end. There's intense pressure to focus and to get in and out of court in as few days as possible. And so even more than before, there's really an incredible amount of pressure on the trial lawyer to make strategic decisions about what to cover and what not to cover. The criteria that I generally use are that I'm trying to choose the evidence and the witnesses that will bring my story to life, my story that leads to the conclusion that my client should win, and supports my trial themes, about which I'll say more in a minute. I also try, if there's adverse evidence and I have a chance to address it first, I try to do that. To disclose it so I'm not hiding anything, and to put my own interpretation on it rather than have it be presented in the first instance by the other side. I try to resist the temptation to use evidence that might support my side or might make the other side look bad when considered in isolation, but detracts or distracts from my overall story and theme. We don't have enough time at trial, and the jury and judge's attention spans aren't sufficient to be taking pot shots in isolation. I mentioned the importance of themes. Having themes is critical for a trial. The themes provide the jury with a template for organizing the mass of information they'll be receiving and a roadmap leading to the desired conclusion of the trial. Effective themes have to fit the facts of the case, but they also need to appeal to the pre-existing beliefs and experiences of the audience. The plaintiff's themes should motivate jurors to protect the patented invention. These are things like the difficulty and importance of the problem solved, the creativity of the inventor, and the value of the invention. There's also an opportunity in most cases to emphasize that the patent was issued by the U.S. Patent and Trademark Office after a professional examination, encouraging the jury to defer to results of that process if they're not certain about technical issues. Plaintiffs may also want to emphasize the importance of avoiding hindsight, emphasizing that in hindsight, even a brilliant idea can seem obvious. The defendant's themes should provide reasons why the patent invention doesn't deserve protection. It's too modest, routine, everyday, and incremental. It didn't involve sufficient inventiveness. It's important for the defendant to formulate a succinct description of what the invention is that minimizes its creativity and explains why it's obvious. So something like, the plaintiff's invention is just doing this existing business on the internet, or it's just the Smith prior art device with an electrical trigger instead of a mechanical one. Something that encapsulates why the invention was obvious. Both sides should develop themes about fairness and the public interest. According to the plaintiff, the defendant is stealing hard-earned fruits of the plaintiff's work. If the accused product wasn't independently developed, the defendant's a copycat, and we all know how we feel about that sort of person. Permitting ideas to be stolen like that discourages innovation. It might even contribute to the loss of American jobs. The defendant may suggest the plaintiff's trying to monopolize technology that should be available to everyone. If you allow the patent process to be abused by patenting routine, obvious improvements, you reduce competition, you keep new and better products off the market, drive up prices, and you hurt consumers. So if we're thinking about the trial as a play, what are the plot points? Well, there's a situation before the invention, the prior art, the problem to be solved. There's the invention itself, the circumstances, what led to it. Having a good story of the invention is very important from the point of view of the patent owner, and having a story where the invention emerges routinely and obviously from what's gone before is very important for the defendant who's challenging the patent. The fruits of the invention, the benefits that have been realized, or lack thereof. The patent examination itself, its thoroughness, how the prior art considered by the examiner compares to the prior art that's going before the jury. And the accused product or process, including how it was developed, whether it was developed independently or whether it's a copy of the patented product. So one of the most important things about a play is the casting, obviously. Each side needs to choose their witnesses, and that's a process that's best started as early as possible. The trial lawyers need to identify, contact, and directly speak with potential witnesses. They could be employees of your client. They could be former employees. They could be third parties. And they can be hostile, at least at first. It's a common situation to have a patent asserted by a company that bought the patent from a previous company whose R&D scientists may have been laid off. The trial lawyers need to form relationships with potential witnesses, try to work with them to figure out what happened, why it happened, and create a working relationship. Potential witnesses need to understand the issues in the case, which often at first they don't at all. They need to review relevant documents and cast back their memories to a time they might not remember very well, to piece together the relevant facts and put them in context. And this often requires an iterative process where counsel are trying to figure out why certain things happened, why certain things didn't happen, and at first people don't remember. They give very superficial answers, answers which could make an invention seem obvious, for example. and it really requires a fleshing out over time to bring back the actual process that happened. In preparing witnesses, counsel need to remember they're not dealing with professional actors. You know, not only for ethical but for practical reasons, you can't just tell them what to say. You can't tell them, you know, what kind of a personality they should try to have. But you know, people and factual histories are complex. People's personalities have different aspects. There are a lot of different factual aspects to a story, and part of counsel's task is to, you know, search within the facts, search within the documents, and search within the personal characteristics and background of your witnesses to find what you want to highlight at trial to help tell your story and develop your themes. Typically, a key witness is the inventor, and you know, there's a very strong inventorship ethos in American culture. People think of, you know, Thomas Edison, the Wright brothers. That's an opportunity for the patent owner if they can capitalize on that. It also can be an opportunity for the accused infringer if they can highlight how different the person or their conduct or their achievement is from what the jury might expect from an inventor. The accused infringer or its representatives can be important witnesses. I feel that on the defense side of the case, it's very important to find some sympathetic witness or witnesses to personify the defendant. You want the jury to know that they're passing judgment on a person, someone whose good name and livelihood might be at stake, and not just some faceless company. I think it's very important in defending a patent case to have the client explain, well, why did it feel it had the right to make this accused product? Why did it feel it was engaged in fair competition and not just ripping somebody off? And often that can tie into themes about validity and specifically obviousness. The most obvious star witnesses in the case with regard to obviousness are going to be expert witnesses. Almost invariably, each side will have a technical expert who will explain how they have analyzed the patent and the prior art and reached a conclusion, typically opposing conclusions about whether claims were obvious. And it's important to look for expert witnesses early and to audition them carefully. The lawyers and even clients often tend to focus on specific credentials, academic credentials, industry experience, and so forth. And those things are important, but I think that lawyers often overvalue them. I mean, fundamentally, the expert witness role is that of a teacher. I look for somebody who can connect with a lay audience, explain technical issues clearly, simply, and believably, and can make them interesting if possible. Other witnesses can be various. Sometimes the best evidence comes from a little bit of a different perspective than what you might expect. So representing a patent owner, obviously the inventor is important, but sometimes I've started trial with somebody who worked with the inventor. For example, a consultant who helped commercialize the invention. And that way you can set context before the inventor takes the stand. So, for example, this person spoke about, you know, how impressed he was by the inventor's, you know, credentials and by the invention, how creative and important it was. And these are things that the inventor, it would be very awkward to have the inventor say directly. By the time the inventor took the stand, the jury was primed for him. In rebutting an obviousness defense if you can get other people to testify. For example, I would have loved to invent this, but it just didn't occur to me. And I was surprised when I heard about it. In one case, I had the inventor of one of the main prior art patents that was being cited by the defendant testify. And the court limited us in what we could have him say, but it was pretty clear that, he didn't find the invention obvious based on his own work that the defendant was citing. So that was a very effective reality check for the jury. So other people can be other supporting witnesses could be customers, economists, marketing people. Often there's testimony about objective indicia of non-obviousness, like, why is it people really bought this product? Was it because this feature was non-obvious, or was it for some other reason? In the background, you're looking for people who will portray, your client as reputable and innovative. Your opponent is a knockoff artist or a monopolist. Sometimes the court will allow limited testimony by an expert on patent law or patent prosecution, the patent examination process, and they can maybe shape subtly the jury's impression about how the Patent and Trademark Office works and how much they ought to defer to the results of the examination of the plaintiff's patent application. So in terms of the phases of trial, you start with your opening statements. Counsel for each side makes an initial statement, and my belief is tell your story, start it right away. Jurors will start making up their minds right away. In the process of telling the story, you introduce yourself, your client, your witnesses, and your themes. This is your chance to tell the jurors what issues are important and what evidence to watch for and why it matters, which you won't be able to do while all the evidence is coming in. But you do need to be very careful what you promise. In closing argument, it's fair game to point out any witnesses that you say you'll call that you don't end up calling, or any facts that you say you'll prove that don't turn out to be proven. Direct examination of witnesses is a really interesting process. In my view, it's a two-part dialogue between the lawyer and the witness, with the jury, you hope, starting to feel like it's part of the conversation. So you really need to carefully, as trial counsel, arrange your witnesses, arrange your questions, tell a story, use an order that flows logically towards your conclusion, and try to hold the audience's attention. I mean, patent obviousness is often about very technical features. So you can use stage techniques to try to hold their attention to the extent the court will let you, like movement, changes of scenery, having your witnesses move around to show things, point at things, variations in time and in tone and tempo. Even asking your own witnesses somewhat confrontational questions as an attention-getting device. You can confront your expert with the opinions of the expert on the other side and have your expert directly answer them. You can anticipate and deflect likely points of cross-examination. It's important to try to develop the character of each of your witnesses in whatever subtle ways you're allowed to do. Try to establish their credibility and support the themes of your case. As a plaintiff's counsel, you want to show the jury your inventor's other inventions and patents. Representing a defendant, you want to show that they've made technological contributions of their own. So as the defendant, asserting obviousness, you have the burden of proof at trial. You have a lot of information to present and a lot of loose ends to tie together. You need to try to present that in a very logical way, find ways to summarize things and then highlight key points with telling examples. Using everyday analogies and comparisons is really important to demystify what might be technical sounding claim terms and technology. Though the plaintiff theoretically has a presumption of validity in his or her favor, that's not something you can rest on. The jury wants to hear, well, why wouldn't a person of ordinary skill have thought of the patented invention? And it's important for the plaintiff to have an answer to that question. It could be that the prior art being cited by the defendant doesn't really qualify as such, that it wouldn't have been regarded as analogous art. It didn't really include the features that the defendant says it did. Or that the modifications or combinations the defendant's arguing for wouldn't have appeared feasible. They would have been unpredictable, or they just never would have occurred to somebody of ordinary skill until the plaintiff invented it, and now they look at it in hindsight. So in cross-examination, it's basically the usual rules that you'd apply in cross-examination in any civil trial. You want to have thoroughly deposed witnesses before they take the stand, and you want to maintain tight control of adverse witnesses using their deposition testimony and their writings. So if you can materially damage the credibility of a harmful witness, then that's great, but lawyers overlook opportunities to make affirmative points from the other side's witnesses. So maybe if you're representing the defendant, maybe you can get concessions that the problem to be solved was already well known, that the invention was identifiable as one of a finite number of possible solutions, the results were predictable. On the plaintiff's side, maybe the defendant will have to admit they knowingly used your client's technology and that they've benefited from doing so. A critical tool in a patent case is trial graphics. You have to be able to show the jury what you're talking about, and you need demonstrative exhibits to help them understand it. They need to be planned carefully and tested in advance. Lawyers typically rely very heavily on PowerPoint slides. I think it's very helpful to have a variety of media to create a sense of movement and change, and take advantage of the unique features of different formats. If the judge will permit you, sometimes it's helpful to have a witness draw on paper or on a blackboard. You can use big poster boards to provide an ongoing reference. I like to have opportunities where possible for my witness to move around, so he could maybe get up from the stand and point to a board. It can be helpful to move back and forth between one format of demonstrative and another. So maybe you have a big board with a bunch of checklist items, and then you go to slides to discuss them specifically. Computer-generated videos can be invaluable to show the inner workings of a device or to show how prior art could be modified or combined. You can show prior art evolving into the patented product. Sometimes photographs, or better yet, physical samples, give a better feeling of authenticity than a computer graphic. Courtrooms typically have visual presenters, which are cameras on an arm that can be used to zoom in on physical objects so that you can hold something under the camera and point to minute features. The jurors really appreciate things they can touch. I like to pass out samples of relevant products or components if that's practical and the court will allow it. Physical demonstrations can be the most compelling thing at a trial, and they're also probably the most risky thing. Everyone thinks of the O.J. trial and the glove that wouldn't fit. Well, hopefully we would all know that you don't hand the physical demonstration over to your opponent to control. But even if you are controlling it, there are numerous ways for things to go wrong. In one trial, we had made a difficult decision to have a really high stakes physical demonstration. The patent claim called for a compressible piece inside a housing. The compressible piece had to be under radial compression from the housing. And unfortunately, our client had admitted in a document that there was such radial compression, but in fact there wasn't. And after agonizing discussion and planning and preparation, we presented each of the jurors with these parts and had them fit the compressible material into the housing and decide for themselves whether there was radial compression. And they found that there wasn't. That's not the type of thing I would normally do because I think there's just too much risk of a subjective decision going against you, or one juror deciding that there's something there that you don't think is there. We sampled probably hundreds of these pieces to see if there were any outliers where there actually would be compression before deciding to go ahead with the demonstration. But the point is that physical demonstrations really can focus the jury and be extremely convincing if you have a very high level of certainty that you'll get the outcome that you want. It's something to consider. So after all the evidence is in, you're going to have closing arguments. The closing is the only chance you have to expressly argue your case. So you can use all of the rhetorical devices, but you have to use an appropriate amount of subtlety. With that proviso, you want to remind the jury, why is your client deserve favorable consideration, and why is your opponent less deserving? Invoke the justice and correctness of your client's position and the unfairness of your opponent's position. So you want to favorably frame each disputed issue, marshal the evidence and arguments for your side on that issue, while refuting those offered by your opponent. You want to illustrate and dramatize your points with telling examples. Quote from the trial testimony. In a trial of really any length, I like to use witness photos as part of the closing to refresh the jurors' memories and give them a kind of a flashback of what it was like having that particular person on the stand. So put up their photo on a slide along with key things that those people testified to or admitted on cross-examination. Show the jury excerpts from key exhibits and from their jury instructions. It's usually best to confront any credibility issues head-on. Help the jurors find clues about what really happened. If this technology was really obvious, why didn't anyone use it before the plaintiff? If it was really non-obvious, why did everybody simultaneously develop it as soon as the market arose? Rhetorically, it's often better not to tell the jurors what to think. Consider ways to poise questions and ask them to decide. Refer back to your opening statement to show that you have shown the things that you said you would show and that your opponent hasn't, if in fact they've missed some of the things that they had promised. I think it's important in closing to go through the verdict form, explain all the questions, and leave no doubt about how you want the jury to answer each question and why. You want to try to close on an emotional tone that wraps together your themes and your conclusion. Thank the jury, sit down, and then you get to wait. So the jury will be presented with a verdict form, and counsel get to wait for the verdict or for jury questions and requests for read back the transcript and whatnot. The form of the verdict is something I could talk about it at great length. It's a complex subject because you may recall obviousness is a matter of law, but subject to these underlying factual determinations. So what does that mean in practice? The most common, even after KSR and other case law encouraging judges to decide obviousness as a question of law, the research I've seen indicates usually jurors are still getting the issue of obviousness. Is this claim obvious, yes or no? And I think the reason for that is it's very hard to get a full jury download of all the factual determinations in a typical case, and then let the judge make the legal decision. You can't ask the jury to write an essay on, what would the Jones reference have taught one of ordinary skill in the art. Now, sometimes the contested factual issues do break down to specific things, and there can be verdict forms that ask those specific questions. Was a particular item of prior art analogous? What is the level of ordinary skill as defined by educational level or years of experience? Did a particular piece of prior art qualify as prior art? Did a particular piece of prior art disclose this particular feature? So in some cases you can have something that once those yes or no questions are answered yes or no, that resolves all the factual issues. But typically the factual issues are going to be sufficiently numerous and imprecise in how they're answered that it's difficult to have the jury answer specific questions as opposed to the general issue of obviousness. So then we have post-verdict, we have post-trial motions and appeal potentially. Since obviousness is a question of law, it's subject to a motion for judgment, judgment as a matter of law, notwithstanding the verdict, where you ask the losing side asks the trial judge to decide the issue as a matter of law. New trial motion, where the argument is that the jury determination was against the weight of the evidence. On appeal from a judgment on obviousness, the theoretical standard of review is that the ultimate question of obviousness, being a question of law, is reviewed de novo. In other words, the appellate court makes its own determination without deferring to the trial court. Since it's a question of law, the appellate court is theoretically as competent as the trial court to decide it. However, the factual component is reviewed for clear error, with the appellate court deferring to the fact finder, whether trial judge or jury, on factual issues. In practice, as I mentioned, the jury's factual determinations tend to be hard to pin down. They're usually not clearly documented. And in that case, the practical question on appeal tends to become whether the ultimate determination is sustainable under any possible view of the evidence at trial, and if so, the determination below will generally be affirmed. So there's often considerable deference, even though this is theoretically a question of law. That said, the U.S. Court of Appeals for the Federal Circuit is perfectly capable of saying, in effect, we're sorry, but under any view of the facts that were presented at trial, this is obvious, and so we're going to hold that it should have been invalidated despite what happened below, or that the patent should have been held to be non-obvious despite what happened at the trial below. So the post-trial and appeal mechanisms are definitely in play, especially in the post-KSR world, but the trial victory is likely to hold sway in most cases, reinforcing the importance of persuading the jury at trial. Well, I could talk all day about what I regard as a truly fascinating subject, but I'll stop here. I hope this has been helpful, and thank you for watching my presentation.